at length and the other develop around maximum half an hour will take. So if your lordship in the meantime finishes other matter before 1 o'clock, because after so one, I think this bench is not available. So before that, I'll come.
May please, your lordship. Earlier listed, but because of some difficulty on our part.
Prayer for listing and upgradation, please give it to the professor.
My lord.
Because there is limited time today.
My lord.
Maybe I beg to mention the upgradation item number 21. My lord.
Just tell the court master.
May I please, your lordship, prayer for listing ballot motion matter, my lord.
Listing, I just said, give it to the court master.
May I please, Lordship, I beg to mention supplementary list item number 26, Lordship. Lordship, the youngest counsel is out of session, Lordship.
26
line.
Which court? Which court? 24%.
Single.
26, we don't have 26. We don't have 26.
Single bed.
May it please, your Lordship. I beg to mention orders item number 22. As the senior counsel, Mr. S. Dotto is out of station, your Lordship.
Item number
22.
22.
Yes, your Lordship.
Okay. This IFO.
Yes.
This is that item 22. This is a custody matter.
My lord. Yes.
Okay. When do you want?
Any day, your Lordship. After puja also may be listed.
It goes after puja because these 2 days, if you can't
Yes.
do, then
Yes,
after
sir.
puja. Okay. Both sides are represented. On the prayer made by and counsel for the applicant, public petitioner. List on, give it. Give it on 14/10/2025.
Obliged.
Daily list item 2.
May please, your
Yes.
problem.
Lordship, since the petitioner is already on bail and we're waiting for instructions, Lordship, this is that matter where they could avail the
Here there's something. Just watch out, we have it.
benefits of car, Lordship.
No,
So
it's okay, but there's something here we. This was the document exhibited. We
Yes.
can't see anything out of it.
Well, Lordship, matter was already heard and last order is 16/7/2025. Directed to me to produce the original document of
You
exhibit
you
one.
have that.
Yes, I have that.
Pass it on. Pass it on.
Government of West Bengal, no?
Can you read that?
Not completely, but better than what
Then it
is
doesn't
there.
help us. Doesn't help us. We just adjourn it. If you can't read, we can't do better.
If you can get a darker copy in a lordship of the Xerox, it would be better.
Dhirendra.
The
Chandranath.
point made by done counsel for the petition and the standing counsel for the other matters. All the matters stands adjourned today. This after the ensuing puja eviction on a date to be fixed by the registry.
Published.
Item
We are putting it to admission. We are issuing notice because otherwise it becomes very difficult. Just before that, you say, as records of the tribunal is received, you should notice returnable forthwith without requiring any fresh steps to be taken. List in the admission column also, last line.
Published. Lord.
Item 3.
Just adjust the language.
Lordship, Vinod will appear in this case. He is out of station, Lord. Matter will be appear for today.
Okay, this is that
Lordship,
illegal detention.
arising out of the same cause of action, your lordship, the fact is that one criminal case has presently been filed against me and pending before at Mumbai, lordship. Therefore, lordship, outcome of consequence of this case and observation it may be required and placed the same. Now, interestingly, in this case, lordship, as of now, lordship, no FIR has been disclosed to me, lordship. That is why, lordship, we should be requiring me to place the same before the court, lordship, the case presently pending in Mumbai. So, lordship, the FIR itself is the public document, your lordship, under section 74 of the Indian Evidence Act, and now
Yes, but
in the
copy can be
same
given.
section
Why you are not
74
giving
law.
a copy?
Lordship,
Where is your
Given.
statement that you applied for certified copy and was not received?
Lordship, actually, fact of the case.
Where is,
actually
where is the statement that you applied for certified copy and was not, you were not provided?
Yes, lordship, I have communicated the same before the officer in charge, lordship, Annexer D, page number 29, lordship, wherein asking to furnish the certified copy or either the copy of the FIR, lordship.
No, this is not how you get copies. How do you get certified copy of
The
the
very
FIR?
interestingly, lordship, only GD&T has been made out arising out of the 54 of 25 GD&T, lordship. The
But
government
tell
has
me,
taken a stand.
You see,
That-
we are here trying to understand,
Yes,
we are trying to learn.
Yes.
How you get copies of the GD entry and certified copy of the FIR? I don't know the procedure. I am asking you.
in CRPC or there is no provision, lordship, prior to registration of FIR, whether certified copy has FIR copy has availing or not, lordship. But lordship, this is very much clear that this is the public document, lordship, under
Please don't
section
waste time. I am
74.
asking you a pinpointed question, give a pinpointed answer.
Yes.
If you want to give lectures, you can go somewhere else and give lectures. We are asking you a pinpointed question. Please tell us, we are here to learn how you can get certified copy of the GD entry and FIR. Only that much. Please restrain your answer to that.
Yes, lordship, definitely I am entitled to get the copy that whatever allegation has been filed against me, that is my right to know what allegation has been filed. As because, lordship, only the police FIR has
The
been
learned,
lodged,
Mr.
lordship.
Mr. uh, M. Saikia, learned counsel for the petitioner, on being asked question as to inform as to how certified copies of GD entry and FIR can be obtained, made his submissions without answering the court query. Full stop. Accordingly, matter stands adjourned today. Next time, the learned counsel for the petitioner shall be prepared to give a written answer to the court query list on 15/10/2025.
Yes. Item 4.
Yes. Any development?
Yes. I have received.
আপোনালোকে মানুহ পঠাইছে এতিয়া অতুত কলিতা যাব তেওঁ এতিয়া ৰাজস্থানত তাক টেষ্ট কৰি টাইম লাগিব one copy my lord that person is dressed out in Rajasthan police escort follow the thread. First. On 19, my lord, your lordship see Pradut Kolita along with staff proceed to Udaipur, Rajasthan. That they are perhaps then that I'm to go okay.
Item 4, 5. Copy दिया ना है कि? ना क्या बात copy पर? We have not been served. It's come for the first time today, Lordship. We'll get our instructions. And extra copies may be served, Lordship.
Today itself. Why?
26. Oblige. Item 6.
Copy also. Give a PDF copy also.
Ma'am, your lordship.
Yes.
This is the petition, my lord. There's some delay, my lord, in this matter, my lord. In paragraph 17 and 18, we have stated the ground of delay,
Page?
my lord. And in my lord,
Opinion is at page
page 20, 20, my lord.
22,
20, 20,
20.
17 and 18, my lord.
No, where is the opinion?
My lord,
Where is the opinion?
learned trial, ma'am. Yes. Sorry, my lord. Page 86.
86.
Page 86, my lord. 86, 87. Like, I like to read this.
86, 87. No,
Yes,
where
my
it
lord.
start? It starts from
Oh, it
where?
starts, my lord. It starts from
78.
78.
78,
2019 opinion, lordship.
2019.
28, 19. Yes.
We'll keep open the question of maintainability.
My lord.
We'll keep open the question of maintainability. What is the explanation you have given?
At paragraph 17, 18, I have stated the delay, my lord. First of all, my lord, in the learned trial court, my lord, has been declared that I'm able to establish my linkage with my parents, but not by parents, linkage with the grandparents. Only on that doubt, my lord, I'm been declared foreigner post 1971, my lord. And my linkage with my parents, it is admitted, my lord, proved. It is in paragraph 86, it is admitted. There is only in my family, I'm only declared foreigners. There is no case against any of the members of my family.
This explanation is not good enough. Okay, we'll keep it open and then see it next day.
my lord.
Maintainability open.
Heard Mr. P.K. Dekalan, counsel for the petitioner, as well as so for the respondents.
Sorry.
Petitioner has filed the given opinion dated page 78.
Yes, my lord.
28/8/2019, passed by so and so in case number so and so. Thereby declaring the petition to be a foreigner who 25 to 1971 stream. Next para, in view of inordinate delay of 6 years in selling the impugn opinion, keeping the issue of maintainability open, issue notice returnable on so and so. Extra copies within 2 days, call for the relevant records from the concerned tribunal. The prayer for bail shall be considered on the next date of listing. In the meanwhile, if the petitioner, namely so and so, alias so and so, is apprehended, he shall not be deported out of the country without order of the court. List on so and so.
Much.
Item 7.
Yeah, please, lordship. Lordship, impugn order, my lord, is 96, my lord. Right. Order is 7/11/2022.
Two. Mr. A. Mubarak, learned counsel for the petitioner. So and so for the respondents. Page 96. When it dated 7/11/2022, passed by so and so in so and so. Thereby declaring the petitioner to be a foreigner post 25 to 1971 stream. Notice extra copies within 2 days, call for the record. Notice made returnable. We give it after 4 weeks, both the cases. The prayer for bail shall be considered on receipt of records. In the meanwhile, if the petitioner, namely so and so, is apprehended, she shall not be deported out of the country without order of the court.
Much.
Item 8.
Yes.
That ex parte order, my lord, page number 17.
17.
17. Relevant portion would be, my lord, para 7, page 19. Record be called in the meantime.
It's A.W. Aman, learned counsel for the petitioner, so and so with the respondents. Page 17, opinion dated 2/8/2023, passed by so and so. In case number so and so, our case number so and so. They were declaring the petitioner to be a foreigner post 1971 stream. Notice returnable on 31/10. Extra copies within 2 days, call for the records. The prayer for bail shall be considered on receipt of records. In the meanwhile, if the petitioner, namely so and so, is apprehended, she shall not be deported out of the country without order of the court. The petitioner shall cause production of a certified copy of the order before the Superintendent of Police Border. Superintendent of Police Border.
Barpeta, my lord.
Perfect. In earlier 2 cases also that cause production of certified copy will be there. Huh?
Grateful, my lord.
Item 9.
May I please, your lordship. Lordship, the impugn
23 of them.
certified copy to engage counsel দিতে দেরি করিলে।
ক'ব নালাগে তুমি আজি সেইটো লিখা। Date to date, deportation.
My lord, 101, my lord. 101. Some bona fide delay is there, my lord, to get the certified copy from the engaged council, my lord.
Mr.
MU Ahmed.
M.U. Ahmed, learned counsel for the petitioner, and so for the respondents. Opinion is at page 101. Dated 26/12/2023. Passed by so and so in FT case number so and so, R case number so and so. They were declaring the petition to be a foreigner post-employed in the 19th century Spain. Notice written up around 31/10. Extra copies within 2 days, call for the records. The appearance for bail shall be considered on receipt of records. In the meantime, if the petitioner, namely so and so, is apprehended, Aisha Khatun is apprehended, she shall not be
Corporate
deported
arrest.
out of the country without order of the court. Petitioner shall cause production of a certified copy of the order before the Superintendent of Police Border, Barbeta, to bring the order to the office of the set authority. List on so and so.
Oh, bless you.
Item 10.
Yes.
May please, your lordship. The impugned order, lordship will find at page 79. It's dated 20th February 2025.
But Mr. A.R. Sikdar, and counsel for the petitioner, and so from the respondents. Opening page 79, dated 20 February 2025, passed by so and so in case number so and so, FT case number so and so. They were declaring the petitioner to be a foreigner post 25 in 1973. Notice returnable in 4 weeks. Extra copies within 2 days, call for the records. Prayer for bail is opposed by the learned standing counsel for the FT matters. Power, considering the projection made in this rate petition. As well as considering the age of the petitioner, the court is inclined to grant bail, 10 days time to be bail, rupees 5,000 to the satisfaction of
SPB Goalpara.
FT within, SP, Superintendent of Police, within bracket border, but it will Goalpara. Okay. List after 4 weeks on the seat of records.
Item 11.
In the 11, my lord, I impugned opinion at page 59. Order dated 31/5/2024.
Some delay.
My lord, some delay, my lord, considering the, my lord, lady, my lord, she may be considered also a elderly lady, my lord, 75 years old.
Huh?
75 years old lady, my lord.
75. Give an exception. Okay, we accept your plea.
My lord.
But we are lenient only for a day, for 2 days. We will come back to the same shape
Yes.
after the puja vacation.
My lord. My lord, festive has the blessing of Almighty, my lord.
Hmm?
Festive My lord has the
That's
blessing
right,
of
that's right.
Almighty, my lord.
That's why we are bending the rules.
My lord.
Ms. Verma, remember, bend it like Beckham.
Bend it like Beckham, Lordship.
I would say yes, then I'm counsel for the petitioner, so and so for the, also heard so and so for the respondents. Impugn opinion at page 59, dated 31/5/2024, passed by so and so in BFT case number so and so, arising out of IMDT case number so and so, thereby declaring the petition to be a foreigner post 1971 stream. Notice returnable in 4 weeks. Extra copies within 2 days. Call for the records. The prayer for bail is opposed by the learned standing counsel for the FT matters on the ground of delay in approaching the court for assailing the impugn opinion. To stop in response, the learned counsel for the petitioner submitted that the petitioner is aged 75 years of age, and therefore is praised for consideration of the prayer for bail. Next paragraph. Considering the projection of the age of the petitioner as 75 years, the court is inclined to grant bail. 10 days time to take bail out of this 5,000 to the satisfaction of Superintendent of Police Border.
My lord, Amin Gaon rural, my lord.
Kamrup, Amin Gaon. List out of 4 weeks on receipt of records.
Deeply obliged, lords.
Item 12.
May it please your lordship. Lordship, opinion is at page 30, lordship. Order dated is 18/2/2025.
No, that came over to the Oh.
We say K. Hazam, learned counsel for the petitioner. So and so for the respondents. Impugn opinion dated 18/2/2025 at page 30. Passed by so and so in case of so and so, reference number so and so. Thereby declaring the petitioner to be a foreigner post 1971 stream. Notice returnable in 4 weeks. Extra copies within 2 days. Call for the records. If prayer for bail is opposed by the learned standing counsel for the FT matters, considering the projection made in this writ petition, 10 days time to take bail out of this 5,000 to the satisfaction of Superintendent of Police Border.
Borpeta, lordship.
Borpeta. List after 4 weeks on receipt of records.
W.
Upgraded item 20.
Yeah.
Lordship, kindly pass over the matter for timing. Sir is on the way.
Twenty-one.
Upgraded item 21.
Mayfield, lord.
Malika Banu.
Impugn opinion, my lord, 103, my lord. Petitioner in custody, my lord. The date of judgment, my lord. And the 103.
Actually, first time,
What is the best document you have to
My
connect?
lord,
it to
the
project?
base document is, my lord, linkage certificate, my lord. Mainly, my lord, land document, my lord. And the land document which was submitted by the petitioner had already executed and the Mondal also deposed, my lord. But the rejection of the Javandi on the digital signature, my lord, page 105, last bottom, my lord, last size, my lord, last. In the cross examination, on that ground, my lord, the land document was rejected. By inherently, the land was,
Where is the document?
my lord, land document, my lord. Javabandi copy, my lord, page 37. Brilliant part, 38, my lord, in terms of, and vernacular part, my lord, is page 41, my lord, vernacular part, my lord. Last, Sakto Vikhayasa. Namdarim Swan Sodod, 30 2024
Where is the
তারিখ
evidence of DW5?
DW file, my lord, Mondal, my lord.
Where is it?
DW5, my lord.
He says that the records, your names do not appear in the Jamabandi records.
No, my lord, that is the another document, my lord. Javabandi copy, my lord, page 95, my lord. They say, my lord, in record, my lord, in page 96, my lord. Javabandi copy in this same that in pursuant to the order dated, my lord, it was typing mistake 30 or 31, it is typing mistake, my vernacular is clear, my lord. 40 the mediation was granted in favor of the Mallika. That is the petitioner, my lord. He stated, my lord. Mallika, daughter of so and brothers also deposed, my lord. Uncles also deposed. Gaubra also deposed, my lord. And this Mondal also deposed before the honorable court. My lord, he in custody, my lord, and date of judgment he was arrested, my lord. On 13.
Where is the entry in the Jamabandi?
My lord, 37, my lord.
37.
On 37, my lord. And vernacular part, my lord, 41, my lord. And my name, my lord, reflected, my lord. Page 41, vernacular, my lord.
Yes, 41.
Yes, my lord.
Serial number?
My lord, here in the last part, my lord, Chakrovikha, my lord. Remarkable Montobbor part, my lord. This side, my lord, serial number 48, Mallika Khatun, and 41, my lord, page number 41, Chakrovikha, Sari, 30/4/2024 তারিখর নামজারি সোয়ানশো হুকুম মতে 234 নম্বর দাগর মাটির উত্তরীয় সূত্রে আসবান দ্যাট ইজ মাদার অফ দি পিটিশনার, মাই লর্ড। দাগ নম্বরত স্থলত মাল্লিকা খাতুন, মাতৃ মৃত আসবান খাতুন আর আবু তালেব, দ্যাট ইজ ফাদার, মাই লর্ড, and mother সিরাজ আলী, brothers and others, my lord.
No, just a moment. 33 তারিখ নামজারি ইমান দাগর মাটি উত্তরাধিকারী সূত্রে But this is in lieu of whom?
My lord, my mother, my lord. My mother.
Where is the
Husband.
entry of your mother?
Husband, my lord.
Where is the name of your mother?
My lord, mother-in-law in land also, voter list also, my lord. And other land, my lord, next.
In this page 40,
Yes, my
Where
lord.
is the name of your mother?
Okay. Husband, my lord. My mother name is husband.
Yes, where is her name?
Mother, my lord. Mollika. Mir Hussain, my lord. Then Azmat Ali. Husband, my lord. 47, my lord. Serial number 47. His name was cancelled and after expired his mother, my name. I put it, my lord. Serial 47. My lord, let the petitioner any grant and then let the matter fixed for.
No, we are just trying to satisfy ourselves with that.
Oh, yes, my lord. Yes, lord.
Because in this remark column at page 40,
40, my lord.
how is your name mutated? My mother's name?
Mother name, my lord. Asaban, my lord.
Uh-huh. Where does her name get entry in the?
And serial number 47, my lord. My mother name is this serial number.
In the remark column, how does her name enter? How is her name entered? Because the finding of the tribunal is that the names are not entered.
But my lord, and did all deposition also, my lord says, my lord, the Mondal say, the report. And Lanet Tribunal, my lord, reject
I
the
will tell you what has happened, why the court has disbelieved it.
digital, my lord, on that ground. My lord.
Well, no, it's correct, not wrong. You see this.
My lord, yes,
this no, just a moment. This case is of 2011. Correct.
Yes, my lord.
Now, in the written statement, perhaps there is no reference to this land. And then come to page 41.
Evidence should be also mentioned, my lord, the land of.
Come to page 41.
And brothers also.
In the middle, 23-2.
Yes, my lord.
চক্র বিষয়ার 23-2-24 তারিখ নামজারি।
Sir.
Correct?
Yes, my lord.
So this name of your mother is husband comes here. Last name.
Yes, my lord.
Aru Asaban.
Asaban.
Correct?
Yes, my lord.
Her name is entered in February 2024.
Before that, my lord, other the petitioner mother name inherit, my lord, next annexure, my lord. Jobandi Gupta, his grandmother, my lord. The land was required from his grandmother, my lord.
I don't know whether I've been able to communicate it to you. In February 24, the name of the mother is mutated. And in April, your name is mutated. And the proceeding is of 2011. Now, let us see your written statement. Where is that?
Written statement, my lord. Yes, okay, my lord.
Is it at page
48, my lord. 48, my lord.
48.
On, my lord. 48, my lord. My lord, 52 page, this is the petitioner mother name recorded as the mutation. And but my lord, the last part, my lord, in evidence in ship, that part was mentioned, my lord. Evidence in ship, kindly see, my lord. Evidence in ship, my lord, page 16, my lord. Serial number 14, my lord. Page 60 and serial number 14, my lord. And page number 61 part is mentioned, my lord. My name is, my lord. Mutation dated 3/0/2024, my lord.
No, Mr. Ali, I am reading into the pattern
Yes, my lord.
because first of all, in the written statement, you must introduce your parents.
Yes, my lord. From mother, my side.
And then the mother, but you see, your father's date of death is not there.
My lord.
The date of death of your father is not there. And in paragraph 14, you say that the name appeared in the Jamamandri due to inheritance and got
Eh.
land from her mother.
Her mother, my lord. Father was expired earlier, my lord. In written statement, it mentioned, my lord, when father was expired, mother was expired, that part mentioned, my lord. My lord, father's 1966, page 20, my lord, one word, my lord. Page 20, petitioner father, mother name. Yes, my lord. 70 also my mother name appear.
Page 65 and 70. Page 65 and 70. This all belong to us. Hasar of Pori village, madam. 65 and 70, madam. 65 and 70, madam. Page 20 and 23, madam. Thereafter, everything changes, madam. The village changes. Yes. They-
That's why we are asking that question. He is claiming to have got the land from the mother. Mother got it from her mother. So that's a missing link we are not be able
Yes.
to connect.
My lord, even the land Jamabandi, my lord, which where the mother's name appearing is enlisted in 2024. There also the, my lord, the husband name is not mentioned along with the.
My husband has different land.
Yes, no, but that's why, my lord,
Husband,
even page 44, the Jamabandi, my lord, where my learned friend is showing the name of the petitioner, the mother of the petitioner is listed at, my lord, page 42.
because we are not finding the date of death of your father is alive or dead.
Yes, my lord.
The date is not easily found. Where is your?
It is not mentioned when father died. Now, my lord, is the husband of page 42, serial number 57. He is claiming this document on the basis of this document,
It's okay, it's 2025.
the 2024.
No,
The-
this, if your opinion is of 2025.
As husband, my lord, husband is described as Mito Safarban Bewa,
My
relative
grandmother.
name,
No, grandmother.
page 42. Serial
no.
number 47.
Page 103, the opinion is of August 2025.
Yes, yes. It is August 2025, my lord. I understood. No, no, what my submission is that, my lord, whether this Asaban, whose name is enlisted in the book, in the my lord, Jamabandi at page 40, page 40 and 47, my lord. 42,
Yes,
my
we will
lord.
examine that, but since it is come within a year,
Because this Asaban is not described as wife of my lord, this Taleb.
not there.
Yes, not described as wife of Taleb, my lord.
It's okay, it says
Asaban is described as
this is an
daughter of
opinion of August. We give,
Sapur.
we understand that there's a gap, we are not trying, we are not unable to find out.
Yes,
You are right. Because in the written statement, it's not there.
written statement.
Since you have come on time. we are
Even one aspect, my lord, another aspect, my lord, because your lordship know it well, my lord. If father is alive, whether mother is alive or not, only
No,
if,
it's not there. That's the problem.
yes,
We are finding a disconnect. Not there. We are not also finding the connect between the mother and the father,
yes.
except for that voter list we have from.
Only the recent, my lord, opinion.
Let Mr. H. Khalil and counsel for the petitioner. So let's go with this guidance. Records have come. Referring to the order dated 59/2025, how the learned counsel for the petitioner has paid for bail. The said prayer is opposed by the learned standing counsel for the FT matters. On the ground that the readings in the written statement and the evidence tendered by the petitioner are at variance and therefore not reliable. Next slide, be that as it may, in view of the nature of projection made in this petition, then it is time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border. Which place?
My lord, in custody, my lord. Nagaon, my lord.
Oh, he's in custody.
Custody, my lord.
Okay, then say that it is submitted by the learned counsel for the petitioner that the petitioner, namely so-and-so, has been taken into custody on
30, my lord, date of judgment. my lord.
Hmm?
30, my lord, 38,
308
2025.
2025. 38/25.
25, my lord. 30,
Same day from the same
yes,
day.
my lord, on the same day, my lord. On the judgment day, he was last taken custody.
in custody on 38/2025, or the day when the impugn opinion was rendered. The prayer for bail is opposed by the standing counsel for the FP matters. Same on the ground that so and so. Considering the projection made in this petition. What is the intent to release, to grant bail to the petitioner, the following conditions? The 3 conditions. You just give it that, because this sorry, this puja one, make it 4 days. SP to take steps within 4 days for release of the petitioner from the. So she's where right now?
Matia, my lord, in Junta Matia. Kendrick Matia.
On the Nazi camp, Matia Gwalpara. Next, by the registry shall issue a fresh reminder for the records of the tribunal by email. Next, list on it 29/10/2025 for receipt of records of the tribunal.
My lord.
Upgraded item 23.
What is time? Because
Yes.
because of this puja holidays and all.
Yes, my lord.
23.
Please.
Yes.
My lord, I for bail, lordship. I'm praying for bail. And it's an ex parte order, lordship. I'll humbly pay for one thing that documents, no shifting. I have annexed along with my writ petition, lordship.
You have the copy of records, Mr. Payne?
Yes.
Last time we handed it to you.
Report is here.
Which page is the opinion?
Lordship, opinion is at page 28, lordship. And he has received the notice, lordship. Re-
My lord, in this case, my lord, the petitioner received notice, my lord. Despite of receiving notice, he didn't turn up. He did not a single delay. Initially, notice could not be served. Later on, my lord, in the new address, the notice was served. It is not the case, my lord, that he did not receive notice. The opinion is of 2017.
In the writ petition, what is the explanation of delay and for not appearing?
Lordship, he received it. He did not understand. He misunderstood it that he had given all the documents to the Gaubura as asked for it, and he had submitted all his relevant documents to the Gaubura. So he did not understand that he had to appear before the trial. The blunder of his life has done that, Lordship. So I humbly pray, Lordship, if one chance, I beg before Lordship, if one chance is given, he won't much time, maybe within 45 days, he will complete the enter because all the documents required is annexed along with the writ petition. If a date is given, Lordship, he will appear and he will complete the trial within 45 days. As his counsel, I give an undertaking before this honorable court, Lordship. He has done his blunder of his life, Lord. And for that, he humbly apologizes also for honorable court, Lordship.
We'll go through the records and pass orders.
Then with regard to records, Lordship,
Yes, we have seen the records.
the reference is not there. The inquiry form and below the inquiry form, they sign, they refer to the tribunal. That specific order of the SP also is not there, and which is there in my pleadings. I have in paragraph 7, I have stated that, Lordship. The record is incomplete. Page 9 of the records, Lordship,
Yes.
2005, Lordship, wherein SP has directed to the SI to conduct an inquiry.
Yes.
And thereafter, Lordship, only the case diary is there. But in the case diary, he is doing his inquiry, but the form, where is an inquiry form, Lordship, that is missing in the record. So in below the inquiry form, the SP border or the DCP border signs and refers it to the tribunal, which is not there in this record, Lordship. Only the statements during the inquiry, the few statements are there. Am I correct, Lordship?
Yes, we got your point.
But since there is a reference inquiry conducted, CD is there, I'm ready to appear and to contest the matter, Lordship. Just one humble chance, Lordship. I just pray for one chance. And he has, for his misdeed, he is really now seeking forgiveness and at least one chance given. And documents are very convincing, Lordship.
Records and keep it day after tomorrow.
If it's tomorrow also, Lordship, I can appear in person before Honorable Court.
No, we examine the records and we'll pass orders. We're fixing it for delivery of orders on day after tomorrow.
Yes, Lordship. I humbly urge before Lordship, I humbly pray. Reason is that Lordship, otherwise he will be stateless. His father is here. Earlier, when his whereabouts was not known, his father appeared before this honorable court. He has done the mistake of his life, misdeed of his life, Lordship. Just one chance, Lordship.
Mrs. D. Ghosh, counsel for the petitioner, as well as so for the respondents. So the submissions are concluded. List on so for orders Friday.
What 1.5 like my lord. Because my lord, my learned friend is saying my lord arguing. I was not on merit because he did not appear even after receipt of notice, my lord. So only I was only on point that my lord the merit we may not go because my lord the whether he is entitled for my lord the benefit of this my lord
No,
principle
you
of
can go
nature.
and address us because once she's made her submissions, we'll have to
Yes.
consider that.
Second issue, my lord, if not when there is a my lord inquiry, it is not that as I have already submitted in numbers of cases, my lord, that this inquiry form is not mandatory after 2005, after the Sabananda Sunwal's my lord judgment, because these forms are my lord as I have submitted, my lord, is only
That's because this is the IMDT reference.
yes, that's why my
So
lord.
in IMDT reference, the form is necessary.
But those have been set aside, my lord. All those have been set aside. The
But
inquiry.
then you see the records. It was earlier an IMDT reference. IMDT reference was reconverted into FT case.
FT,
So now you can't say that the form is not
now,
not
my lord,
required.
that is the point, my lord. Whether on the basis, if suppose there was an inquiry prior to 2005, and if abject form of my lord, the process of IMDT was not followed.
In Sarwan Sonwal,
It
it
is
doesn't
said-
say it. It says transfer the case.
Transfer the cases and the my lord, the form IMDT and the process which was initiated, taken place, which was followed, those were my lord, not accepted as my lord, proper process. However, all the matters were subject to transfer.
Once
So
it is
can we
transferred, it's
enter
transferred.
whether the my lord, the opinions, that's why my lord, in numbers of cases I argue prior to those opinions where my lord, those my lord, inquiry which were met prior to 2005, prior to Sabananda, can we enter in the merit whether this my lord, opinions are my lord, this inquiry are correct or not? Because it is only by the Sabananda Sunwal who has given us
Check the records and then tell us. Check the records and tell us.
no, that's why, my lord, not only in this case, my submission was, my lord, suppose 2005, prior to 2005.
What happens if the reference itself is not there?
Yes, my lord. No, suppose, my lord, I'll go through, my lord. Suppose an inquiry was made prior to 2005, my lord. The procedure of IMDT was not followed in the in that inquiry. Now, Sabananda Sunwal has rightly or wrongly, my lord, sent all the matters to the foreigners tribunal. Rightly or wrongly sent all the matters to the foreigners tribunal. Now, my lord, can we ask the question? There's this inquiry, during inquiry, these formalities were not filled up as per the my lord IMDT. So this inquiry is bad. We cannot say that because this is yes. Yes. So that is my submission. I don't I'll say jump.
Lordship.
This is a case, my lord, where it is to be interpreted in this manner. prior to this inquiry was directed, the IMDT was not, IMDT was there. And during inquiry, probably, during the exact time of inquiry, the IMDT has got, the IMDT is set aside. So all these matters were transferred. Probably for that reason, there is no specific reference from SP. SP had made a direction on 5/7/2005. Exactly on date, during that period, probably IMDT was there. But this inquiry completed on 23/10/2006. So during that time, IMDT is no more. It's in the transit period. So whatever matters were there, all were packed and transferred to Malad. That is the situation. So now in that case, Malad, suppose the form is not there, can we say that this is bad? Because Sobananda Sonowal has said that procedure which was followed in Malad inquiry and all other aspects, even in inquiry, is not proper. So that is not as per law. So that is set aside. Now we cannot say this inquiry form is not there. So for that Malad, the inquiry is bad. We cannot say, because rightly or wrongly, Sobananda Sonowal has given us the direction and we are accepting the references, which were pending before it, either in the tribunal or in the inquiry official. Even in those cases, well, the IMDT, the scrutiny committee was there, at that time. In those cases where IMDT scrutiny committee returned, that it cannot be accepted it cannot be sent for tribunal. Those were also directed to send to the tribunal, So under that situation, these matters were transferred. That's why, in numbers of cases, I argue, those references which were made prior to 2005, prior to IMDT, we should not enter in the inquiry process, whether this inquiry is correct or wrong. Because we got this jurisdiction only from Sobananda Sonowal. Had Sobananda Sonowal been not there, we would not have. Now we cannot question the Sobananda Sonowal. If somebody is aggrieved by that sending to the foreigners tribunal, then they have to go to this silence. They have to silence the Sobananda Sonowal. The Sobananda Sonowal is not right, because our matter could not be sent to the foreigners tribunal because this inquiry was not correct at that time. That have to be done. Otherwise, we cannot challenge that inquiry.
May I submit, if I'm allowed, Lordship?
Yes.
My lord, if we see the case record, I have made a note. So the inquiry, although the direction was made 5/7/2005, but the entire inquiry is conducted, case diary, as per the case diary reveals in page 10, page 11, 12, 13, and 14, Lordship. It's at the fag end of 2006, 23/10/2006. So it's post Sarvananda Sonowal, Lordship. Suppose Sarvananda Sonowal IMDT is not there, so the inquiry form, and then the specific reference has to be made to the tribunal, Lordship. That is missing. But if I timing also, okay, there is a doubt against my citizenship, I'm ready to do that. This is an incomplete record, which I have pleaded also in my pleadings, Lordship.
Okay, we'll consider that.
Yes, Lordship. Deeply obliged, Lordship.
I'm being item 20.
Right, Lordship. Lordship, hearing imping opinion is page number 47, Lordship, the annexer 14, Lordship. Only one piece, the ex parte opinion loss is 47%, 25%. Last piece loss of the equation. Lordship, so herein lordship, with due respect lordship, so my father name is not matched lordship. It's an allegation imposed by the concerned police lordship. So it's a falsely imposed lordship, the source of the allegation. So herein, accordingly, Muhammad Amiruddin lordship is a father name lordship. So originally my father name is Lalu Mia lordship. And that part I have appended lordship the page number.
What is your explanation for not contesting?
So, so notice was, as per the statement lordship of the concerned department lordship, so notice was served, but lordship, so as per record lordship, the petitioner did not receive any of the notice lordship. That notice has forcefully served at the statement of the concerned department lordship. So that part I have stated in my additional affidavit lordship. And in my writ petition, I have stated page number 14 lordship, para number 16 lordship. Para number 16, page 14 lordship. So concern the delay part lordship. Para 16 lordship. Para 16 lordship, page 14 lordship. Judgment dated 7 to 2016. And the petitioner has nothing knowledge in this regard, lordship, fully unaware in this regard, lordship. So expert degree was passed, lordship, in the year 2016, lordship. So because lordship, the notice did not serve by the concerned department, lordship, and that part has forcefully served notice, and in the statement in the
You are reading where? Where you are reading?
so lordship,
Page 14, which paragraph?
so lordship, para number 16, lordship, from the
15.
16, lordship.
16.
16, lordship. The humble petitioner expressed the petitioner being the labor trade of the Bokazan. Herein the judgment was passed on so by the land tribunal Karbiang Assam Nevertheless, the petitioner who has nothing any knowledge about the above stated reference case or opinion passed by the tribunal. He has failed to file the case challenging the expert imping opinion in appropriate time before the honorable court. Therefore, the honorable court kindly be considered condoning the delay in taking cognizance of the case. So he has nothing knowledge in this regard, lordship, and the expert degree was passed, lordship. Expert opinion was passed.
Definitely, if he does not appear before the tribunal, he will have no knowledge.
So my respectful submission is here, lordship. So herein, my father's name is not matched, lordship.
You don't forget about your father's name. You received notice and therefore it did not appear. After that, how do you expect knowledge to come?
So come to know when the detention, lordship. So after detention, lordship, a criminal petition was filed, lordship, and that criminal petition is annexer 1, lordship, which I filed, lordship, and the subsequently court is allowed to liberty if you file it. Annexer 1, lordship. Page 18. Page 18, lordship, California. The relevant part is page 19, lordship. The state criminal petition was closed, lordship, with liberty to file a fresh petition, lordship. Thereafter, lordship, the petition was filed before the another fresh petition, lordship. Order dated 27/6/2025, lordship. Case number 19, lordship.
Mr. Das, in paragraph 5, you have admitted that you have received notice. Once
So-
you admit receipt of notice,
So what
whether you
kind
are
of-
aware of it is or not is not the concern of the court.
So Lordship, with due respect, Lordship, so when the concerned police was arrested, Lordship, so after file the criminal writ petition and during the detained Lordship, so they file a affidavit and I stated Lordship that they have, the petitioner has received the notice, Lordship. So the receipt did not receive, Lordship, that notice has forcefully submitted by the concerned department, Lordship. Forcefully submitted, Lordship.
Okay. So your fundamental rights are violated if notice of the court is served on you, forcefully served, without your consent.
So, Lordship, because my father name is not matched, so that's why, Lordship. So reluctant to receive the notice, Lordship. So they are. Paragraph 6 of the earlier judgment of this honorable court, my lord, page 20 of the writ petition. Page 20 of the writ petition, paragraph 6, ma'am. That may be seen, ma'am. Page 20, paragraph 6 of the writ.
It is in that record.
Yes, madam, in that record. The notice, whether notice was served or not, whether he is the same person or not. For that purpose, madam, the FSL was done. It's confirmed the same person. So during the detention, Lordship, so the petitioner came to knowledge in this regard, Lordship.
Hmm.
And the petitioner in detention since last 123 days, Lordship.
So the identity was disputed. And therefore the FSL was conducted.
Yes, madam.
Okay.
FSL said it is same, it is the same person, madam. So, Lordship, with due respect, Lordship, so basically, Lordship, what is the father name is not matched. Father name is originally the Lalu Mia, Lordship, and that part I have appended, Lordship, the NRC, page number 32, Lordship. Can you find, Lordship, page 32? So, page 32 is the NRC, Lordship. So, wherein Lalu Mia is my father name, Lordship, originally, and the imping opinion is Amiruddin, Lordship. Is a different person, is a father name. So far concerned, Lordship, the so far allegation is falsely imposed by the concerned department, Lordship. Lordship, with due respect, Lordship, so I may allow to refer the matter before the tribunal, Lordship, to establish section 9 of the Foreign Arts Act, Lordship, 1946, Lordship. If there any confusion in this regard, Lordship, your father name is unmatched on that way, Lordship, I may allow to before the tribunal, Lordship, to so because, Lordship, my father name is not matched, Lordship. No, Lordship. Yeah. So, Lordship. Yes. Lordship. So, Lordship. So, Lordship, one particular Lordship, so may I read, Lordship? So, yeah, Binita Nivedan is a মতে নোটিশখন জাৰি কৰা হল, কিন্তু সন্দেহ ব্যক্তি জনে নোটিশখন গ্ৰহণ কৰিবলৈ অস্বীকাৰ কৰিছিল। সন্দেহজনে কোৱা মতে আমিরুদ্দিন
Petitioner got page manifest. Petition forensic of petitioner B3. 8 year time impression.
It is only the responsibility of the court to read. Okay, we'll pass orders.
The petitioner did not appear, Lordship. The other person has submitted the application, Lordship.
No. My learned friend, my lord, page 21 of this record.
We have seen that the thumb impression is there, that thumb impression was taken and
That's
thumb
why
impression
this
matches.
Yes, this thumb impression and the present thumb impression of the person who is in the detention, those were met and those were sent for FSL.
You will not know
FSL
because you see, it's very difficult to read records. You will not know anything. I don't blame you.
FSL confirmed it, both
If you
the
don't
person are the
read-
same person.
If you don't read, nobody can help you.
So,
It is only our business to read. That's the difficulty. We'll pass orders in the chambers.
So, Lordship, then opportunity before the tribunal, Lordship. Okay, sir.
Already
They are
brought.
in Guwahati, madam.
Guwahati.
Oh, okay.
Boronu PSM.
Oh, okay, they've been brought from Rajasthan. And this, and is likely to be produced before the concerned court in course of the day to day.
Subject to pleasure of the court. Possibly, since he is minor, who less is the minor. So
Pregnant.
possibly,
He's pregnant.
he's also pregnant. Her statement may be recorded.
No, you see, we are exercising jurisdiction on under habeas corpus.
Yes, but that's what.
So therefore, if the police will produce it before the magistrate, they will have to make a request to have the statement recorded.
Yeah.
Because what the requirement of law, just Mr. Das. Okay, you see, the requirement of law is that This is the matter before the appropriate bench on 14/10/2025.
Cross. Cross.
Obliged.
This is again providence.
Lordship. Yes, sweet.
Certain things are beyond our control.
Lordship,
Yes, yes,
lordship.
beyond our-
Beyond our control.
This one.
Deeply obliged.
The other day I was reading one book by someone, I not refer, Dr. Radhakrishnan's Basic Writings. Somewhere it is written, my lord, certain things are in this world, certain things are uncertain. We should leave it like that. One should not try to find out why it is uncertain, where is the certainty.
We'll also have to understand, live is LEAV or LIV.
There are many such things.
Apply that.
Item 13 for admission.
May it please your lordship. Lordship, pursuant to the order passed on my lord 11/8/25, my lord, petition.
Pending activity, there is close to it. Next to pending activity, close to it. Itu. Apply कोई भी नहीं. तो internal पूरा तो की result का अपना कर है time at pending में था. Lordship, pursuant to the order of this honorable court passed on 11/25, my lord, petitioner taken back the original exhibits from the tribunal, my lord, and now she applied for, my lord, registration under the new amendment, my lord. So my plea that till, my lord, this decision is taken, my lord, my petition may be keep pending, lordship. We applied on, my lord, 5/9/25, lordship. Yes, my lord. Yes, lordship.
Petitioner submits that pursuant to order dated 11/8/2025, the petitioner has collected the original exhibited documents from the
Tribunal Jorhat, lordship.
Foreigners Tribunal, Jorhat, and on 5/9/2025, the petitioner has applied for registration of his name before the concerned FRRO.
Yes, lordship. So online.
Before the jurisdiction, FRRO. Post up. Accordingly, upon such submissions, the matter stands adjourned today. List after 4 weeks on a date to be fixed by the registry.
Yes, obliged, lordship.
14.
Lordship, DNAT is out of station for medical purpose.
Oh, yes.
There is a direction to pay 2 lakhs rupees.
Yes, you got it.
Last 2 occasions, they have took time, till that,
Petitioner have not received.
Letter may be
Yeah, no.
taken,
Do you
After
have
vacation,
instructions? Do you have instructions about the payment of money?
actually, this is not with me, lordship. DNAT may have lordship.
Okay, he's unwell. But you communicate our order that if not already done, this amount of 2 lakh rupees will be released. Correct?
Yes, lordship.
So our downloaded order, you send it. Heard Mr. K. Kalita, then a counsel for the petitioner. Next, Mr.
N Kolita, N,
N.
lordship.
Kalita, learned
ZA, lordship.
a government advocate. You a government advocate,
Yes, lordship.
learned government advocate has prayed for an adjournment as Mr. D. Nath, learned senior government advocate, is out of station. Next para. Next para. In the order dated 5/9/2025, the court had recorded that the learned senior government advocate had expressed that he was expecting the necessary formalities and approval of the competent authority to be made in the meantime, to be made within 10 days from the order, so that the interim compensation of rupees 2 lakh can be paid to the petitioner. Next para. The learned government advocate shall send a downloaded copy of this order to the competent authorities so as to inform the court on the next date of listing as to whether the interim compensation amount has been paid to the petitioner or not. Next para, list on 15/10/2025. Just before that, you say the pendency, it is made clear that pendency of this reputation shall not be a bar for the competent respondent authorities to release the interim compensation to the petitioner.
Much obliged.
Obligation. 15.
You've seen the records?
No, lordship.
Records are with you.
Oh, yes, lordship.
There are reference made to two opinion. One is at page 104 and one is at page 88. By subsequently, the brother of the petitioner was declared to be an Indian.
Yes, lordship.
We wanted you to examine if both
Yes,
the
yes,
documents are same.
Yes, lordship.
We wanted you to examine if both the documents are same.
Yes, lordship. Record is with us, lordship.
You've seen that, you examined it.
Yes, lordship. I have seen, but today I have not brought the record. Sorry, lordship, for that.
Okay.
If lordship. Tomorrow, if possible, lordship, tomorrow, lordship, taken up this matter.
Both sides are represented. Mr. G. Sharma, and standing counsel for the FT matters is submitted, but due to inadvertence, he has not brought the records of the both the records of the learned tribunal, which is retained by him. Next para. For the next date of listing, the learned standing counsel for the FT matters shall address the court after perusal of the records. Next para, list on 16/10/2025.
Lord.
Lordship, petitioner is not on bail, your lordship. may I make a humble prayer for bail, Your Lordship.
Cannot be deported, Lordship.
That's what I have already, yes.
A statement.
My written statement, Your Lordship. She has filed two written statements. Page 50 onwards, Your Lordship.
80.
50, Your Lordship. Thereafter, file another additional written statement also, Your Lordship, 52 onwards. 50, 51, and thereafter 52 onwards.
It's outside, Lordship, otherwise.
65.
Petitioner is prayed for bail, which is opposed by the learned standing counsel for the FT matters. On the ground that the petitioner would not be entitled to claim benefit of a subsequent opinion dated 5/11/2020 passed by the passed in the case of the projected brother of the petitioner. As the opinion rendered in the case of the petitioner was, in all probability, has not been produced before the learned tribunal. Be that as it may, considering that that at the time of filing of this writ petition, the petitioner claimed to be 59 years of age, and therefore she would be about 55 years of age at present. While the court is inclined to grant bail to the petitioner, namely so and so. Then it's time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Baksa. BTAD Kumasa. It is provided that it would be open to the Superintendent of Police within bracket border bracket with Baksa to impose conditions of to impose such conditions on the petitioner for appearance before the jurisdictional police station or before his office as the said authority may so deem fit and proper. List on, it's same 1610. You provided that they will give conditions.
Item 16.
My lord, LCR was called for and interim order was not granted today, my lord. May I pray for consideration of interim prayer, my lord. LCR has come, my lord.
Yes, what is the best document you have to connect
Lord,
to your projected parent?
I exhibited my all documents. Page number 14 is the 66 brutalis in the father of the petitioner. Page number 66. And page number 14, my lord, 14.
Your
Sher Ali is a father. And so far link is concerned, page number
where is your written statement?
written statement, page number 51, my lord.
51.
My lord. his, her brother was examined as DW2, Gabura was examined as DW3. And Ponset certificate was issued and Ponset certificate was exhibited, but the author of the Ponset certificate was application was submitted for examination, that was rejected, my lord. That was rejected on 11/7/18, my lord.
What is your name?
Rohimon Nessa,
Rahiman Nessa.
my lord.
Your name appears in which voters list?
My lord.
In which voter list your name appears?
My lord. Uh, Before Mary, she was under 18, so father's name along with her father, his name was not enlisted, but link documents are concerned, my lord. Zomabandi copy with her father, my lord, is 38.
It was not exhibited, Lord.
And the consent certificate was exhibited as Exhibit D. That was application was rejected for examination of the secretary, my lord. But the Gabura was examined, my lord. And these are
Gabura was
the
examined.
link, my lord. My lord.
Your name does not appear in the voter list.
My lord, one voter list is there, my lord. That was not exhibited. Page number 49, my lord. Rohimon Nessa, but the spelling mistake is there, my lord. 49. 50, relevant part. Tanmay is the husband, my lord, after marriage.
Page number? Your voter is that page number?
Page number 50, 50, my lord.
50.
Along with her husband name.
No, Mr. Ali, we are maintaining the order of not to be deported.
Well,
There are
the female person, my lord, that is why I pray for bail one, my lord.
But
Maybe
reasons-
allows to submit her bail one, my lord.
there are reasons for us to come at that conclusion.
Till the next of date of next hearing, my lord, for the time being, she may be protected female
No.
person, my lord. For the time being, my
In fact, they are examining the records. We don't want to dispose it of today. Today, just before, 1 or 2 days before vacation, we are not going to.
my lord may fix on any other day. my lord.
This. Both sides are represented. The records of the tribunal are received. Next. The learned counsel for the petitioner has paid for bail. On consideration of the materials available on record, the court is inclined to extend the interim protection granted by order dated 14/11/2024 by providing that till further orders, in the event the petitioner, namely Rahman Nessa, is apprehended, she shall not be deported out of the country without the order of the court. There are basically two reasons. Number one, in your written statement, your brother's name is not there. And secondly, there is a variance in the cross-examination of your brother and you. Your statement is that your father died prior to 1989. But your brother says in your cross-examination
40 years ago.
that the father died about 40 years ago. So there's a mismatch of 12 years. That's why. Any other matter left out?
My lord, next matter is also my case, my lord.
Item 17.
My lord. My lord, there is no interim, my lord. Here also father's name appeared in 1966, my lord.
Any other document except the father's?
My lord, the petitioner's name along with the father 1997, and mother was examined as DW2, my lord. Gabura was examined as DW3, my lord. All are in favor of the petitioner, my lord.
Okay, here if the mother is examined, give him bail then,
My
the petitioner. We are taking your word for it. We have not gone through the records. Can we take your word for
deeply
it?
obliged, also.
Can we take your word for it? Can we take your word for it?
My lord, my lord.
Yes.
My lord.
Had Mr. A. Anil and counsel for the petitioner, as well as so and so for the respondents. Next paragraph. The records come. The pursuant to order dated 22/1/2025, the records of the tribunal is received. No, you've already given bail. You've already been granted bail.
No, bail was not, I think.
Yes, if you miss the bus and you're gone.
Not I'm not
Give the
aware.
order. There's already an order of bail. Now for further travel, you have to upgrade yourself to business class. Economy class will not do now.
I'm sorry, my lord, I was not aware.
Okay, personally represent as the records are received. The court is inclined to issue a rule returnable forthwith without requiring any fresh steps to be taken. Next, this is the matter for hearing in the first week of December 2025.
My lord, one prayer, my lord, some time may be extended, my lord, I will appear.
No, not without any application.
My lord,
It is not on, that's why he said, now I have to travel business class. Any other matter left out? 18, 19. Item 18. We are extending the interim order not to be deported.
Lordship, kindly for timing, interim may be granted, Lordship, because I have a very good document, Lordship. My father also casted, my father name is also appear with my grandfather, Lordship. Page number 81.
What is your document connecting to your projected parents?
Lordship, the school certificate is there, Lordship. It was also duly proved. Page 103, Lordship.
103.
Yes.
Where is the evidence of the school teacher, principal?
Lordship. Page 73, Lordship.
No, but then you will not be entitled to bail. Just see the what's the records are here. The original admission register was not brought.
Admission register is there in the record, Lordship.
Is there?
I have gone through the record, Lordship, but there is no allegation against me also, Lordship.
It was a. Sign for an eye. Sign for an eye on it. No, you were, there's deficiency in the conduct of the case. The document is available, but that was never proved.
Yes, Lordship. But admission register is in the record, Lordship.
No, but it's not proved. The conducting lawyer should know how to conduct the case. The document is there, but it's not.
Lordship,
not
in the deposition of principal also, it is stated that the counterfolio of this certificate as exhibited H as available in our office.
counter foil is available in the office.
Yes,
Doesn't prove anything. And this admission register he brought, but that was not exhibited. This is the document. The document, the principal had bought it. Yes. But your council did not prove it. There's no signature of the tribunal. It was not introduced in the evidence. So therefore, this is not proved.
Yes, we can the original. Yes, that's it. Okay. In original. Yes, that's right. But my name is appear in serial number 3. Yes, that's.
There are, yes. There are some discrepancy in age also, Lordship. Yeah.
Yes, Lordship. Interesting. In this matter also interim is not there, Lordship. Lordship, I have annexed one voter list of 2025, which my name is appear with my mother, Lordship. HP 75. Yes, Lordship. Residential certificate is also there, Lordship. Amisha Khatun is my mother. Return statement, Lordship. Page 40, Lordship. Yes, Lordship. Lordship.
Is the name of your mother disclosed? Okay. Although it's not an exhibited document, but he has shown a connect. Mr. A.K. Ajong, learned counsel for the petitioner, as well as so-and-so for the respondents. Next is the records of the tribunal is received. The learned counsel for the petitioner has prayed for bail, which is opposed by the learned standing counsel for the FU matters. On the ground that the that there is no flaw in the opinion rendered by the learned tribunal. Next para, be that as it may, in view of the projection made in this writ petition, court is inclined to grant bail, 10 days time to take bail or rupees 5,000 to the satisfaction of Superintendent of Police Border,
Borbetta, Lords.
Borpeta.
Yes, Lords.
Next para, it would be open to the Superintendent of Police, within bracket Border, Borpeta, to provide such provide such conditions for appearing for the such conditions for grant of bail, requiring the petitioner to appear before the requiring the appearance of the petitioner before the border branch of the Superintendent of Police Border, Borpeta, for recording his presence before the said authority. As far as the records are received, this is the matter for that the court is inclined to issue rule returnable forthwith without requiring any fresh steps to be taken. List the matter for hearing in the first week of December 2025.
Deeply obliged, Lords.
Okay. List again in the motion column. After the ensuing is a vacation on a date to be fixed by the registry. Mr. Dhar, you don't know. You don't know. No, we have seen that in the Agricultural University, but
Item 2.
these are few things which makes us smile. Otherwise, it would be monotonous. Mr. Dhar, you wanted to say something? No. Okay. Yes, item 2. Yes, Mr. Dhar, you are appearing for the department, or Mr. Hendrik, you will be appearing for the department. What is your instructions? Appointment of Gambura, Gaon Pradhan. What is your instruction? Okay, then file an affidavit then. File an affidavit then. Okay, there is no representation from the petitioner. However, Mr. J. Hendrik, learned standing counsel for the for the Revenue Department, as well as Mr. R. Dhar, learned additional senior government advocate are present. Next para. The learned additional senior government advocate has submitted that he has received para-wise comments regarding the background in which the respondent number 4 was asked to discharge the duty of Gaon Pradhan of Bhogamur, Bhogamur, Bhogamur village. So an affidavit will be filed to that effect. list again in the motion column on after the ensuing puja vacation on a date to be fixed by the registry.
Item 3.
Yes. Compassionate appointment. Okay. Where is your application? You claim on behalf of your father. You claim appointment on behalf of your father on the death of your father, husband. The husband died 2010. Husband died in 2010. But then, But then that decision says if it 2 years it is pending, it will has deemed to spend force. No, the High Court, Achyut Ranjan Das. Now, where is the SLC decision? 3-0. Where is the SLC minutes? Forty-five. Just a moment. Just a moment. Just a moment. But Mr. Ali, there's no vacancy at page 60. There's no vacancy. We can't. But after the High Court order, it was placed before the committee, and if there's no vacancy, they can't create one. Yes. That has been considered and rejected. But that has been considered and rejected. Once the scheme is gone, how can we now bring back the time with the clock? and they have rejected it, page 60. They have rejected your application. They considered it in the meeting and then sent the vacancy position, and it was nil, and therefore it was rejected. So it was taken up. And now the scheme is not there. We can't make a direct appointment to be made without the scheming there. You understand that, but it's just. So once the scheme is not there, we can't issue a direction. The appointment has to be in terms of the scheme which is available. You see, it is not a question of disrespecting the earlier orders of the court, but it's a question of the scheme being available. But the vacancy position is nil. You see, vacancy does not mean the entire vacancy. It must be within the scheme of 5%. Vacancy must be, you'll have to demonstrate that it was within the 5% available vacancy. No delay, we are not inclined to accept that there is a delay. The petitioner has been agitating thrice, she has come to court. Then you'll have to challenge that earlier order of this court. This court had issued a direction, it has to be complied with. If there was a delay, you should have challenged it for the Supreme Court or before the division bench. And that's all, that we are unable to accept. That immediacy of the issue is lost. There's not one, there are 3 orders of the court. But Mr. A. Ali, learned counsel for the petitioner, as well as Mr. R. Dhar, learned additional senior government advocate. As well as the learned standing counsel for the handloom, textile and sericulture department, representing all the respondents. The case of the petitioner is that her husband, late Rupi Kanta Pegu, RUPI, Kanta Kanta, Pegu, while working as grade 4 employee in the office of Superintendent of Sericulture, Janai, Dhemaji, had expired in harness on 25/5/2010. The application of the petitioner for appointment on compassionate ground was taken up by the district level committee in its meeting held on 27/6/2011, and the name of the petitioner was recommended for appointment on compassionate ground. Full stop. As the appointment of the petitioner did not materialize, she had filed WPC 1978 of 2016, agitating her non-appointment on compassionate ground, and this court by order dated 26/4/2016 had issued a direction that the case of the petitioner be taken up before the SLC the case of the petition shall be placed before the SLC within a period of 30 days. And the result of the SLC be communicated to the petitioner. That SLC, you write the full form, state level committee. Then SLC was short. Full stop. Next para. Despite the said order dated 26/4/2016 being communicated to the respondents, the SLC had rejected the prayer for appointment on compassionate ground, the same was brought to the notice of this court, which is recorded in the order dated 9/9/2016, passed in contempt, cont case within bracket C 444 of 2016. And the petitioner was further informed that, and by communication dated 30/7/2016, the petitioner was informed that a claim for appointment on compassionate ground was placed before the SLC held on 1/3/2013 and 30 January 2016, respectively, but a name could not be recommended. Full stop. Next, the aggrieved petitioner again approached this court, and this court by order dated 30/10/2017, passed in WPC 6440 of 2016, took note of the minutes of the SLC held on 1/3/2013 and 30th January 2016, and issued a direction that the case of the petitioner be given a fresh consideration by the SLC strictly by following the provisions of law as laid down in the case of Achyut Ranjan Das. Just find it out, huh? Achyut Ranjan Das, it should be 16 4 SCC. Next para. As the case of the petitioner was not considered, the petitioner filed a contempt petition being con case 477 of 2018, and this court by order dated 4/1/2023 directed that the recommendation of the DLC dated 27/6/2011 be placed before the next available SLC full stop. By a letter dated 30/11/2024, comma, the petitioner was that is recommendation dated 30/11/2024 within bracket lecture Y. Something is wrong in your numbering. Page 57 is annexure U. Page 58 is annexure W. 59 is annexure X. Page 60 is annexure Y. Acha, annexure Y, page 60. huh? Comma, the petitioner was informed that the candidature of the petitioner was approved in the SLC dated 2/5/2023 for the post of grade 4 with a recommendation to forward the proposal to another administrative department under clause 15 of the OM dated 1/6/2015 as the vacancy position of grade 3 and grade 4 post for appointment on compassionate ground under the handloom, textiles and sericulture department was nil. And the petitioner was further informed that most of the departments have informed their vacancy position is also nil. And therefore, the petitioner was informed that she has not been appointed till date despite of a candidature being approved by the state level committee. Next para. It appears that the petitioner has also filed a contempt petition being registered as cont case C 289 of 2024, where a notice has been issued by order dated 13/12/2024. Next para. The learned counsel for the petitioner has submitted that despite several orders of this court, as well as the SLC approval, by meeting dated 2/5/2023, the petitioner has not been appointed, the present writ petition has been filed under Article 226 of the Constitution of India. Next para. The learned additional senior government advocate has submitted that in the meantime, the government of Assam wide, where is that notification? Right, that is an OM. Right, an office memorandum dated 18 September 2022, comma, the government of Assam has withdrawn the compassionate appointment scheme, and the same is substituted by another scheme called so and so. Give a gap. Next one. On considering the entirety of the matter, notwithstanding that there are orders of this court directing the case of the petitioner be taken up by the SLC. And it is also noted that the SLC in its meeting dated 2/5/2023 had recommended the name of the petitioner for appointment on compassionate ground. However, the court also takes note of the fact that in the communication dated 30/11/2024, referred above, the vacancy position of grade 3 and grade 4 for appointment on compassionate ground in the handloom, textile and sericulture department was nil, and most of the other departments have communicated their vacancy position as nil. And in the meanwhile, the scheme of appointment on compassionate ground, it has since been done away with by the state government. The court is of the considered opinion that on the scheme being withdrawn by the government, the petitioner was not be entitled to appointment on compassionate ground. But Mr. Dhar, once the SLC approves it, then the petitioner would be entitled to apply for the the benefit under the new scheme that she'll be entitled to, because she's been held entitled to appointment. So here also the cutoff date is 1/4/2017. Moreover, as per the contents of the OM number ABP, full stop 104/2024/90 dated 18/9/2024, comma, the inverted commas, compassionate family pension scheme in lieu of compassionate appointment, invert comma closed, being made applicable for those employees who died in harness on or after 1/4/2017, comma, in the altered position, the petitioner would not be entitled to any relief in this writ petition. Next paragraph. Under these circumstances, comma, the court is inclined to refer to paragraph 7.5 of the decision of the Supreme Court of India in the case of State of West Bengal versus Devobrata Tiwari and others, DEBA Tiwari and others. That is uh, within bracket 2023 bracket close 0 supreme within bracket SC bracket close 191. Next paragraph, in view of above, comma, the writ petition stands closed. The parties are left to bear their own cost. This is the one.
Item 4.
Pardon me. IA. Yes, this is Ms. Bhattacharya. Ms. Bhattacharya, this amendment can be allowed? Ms. Bhattacharya, this amendment can be allowed? No, he is paid for amendment. He is paid for amendment. IA is for amendment. Can you allow that? He wants amendment in the cost, in the synopsis. In the list of dates. Index. And wants addition in that paragraph. Sorry. Cost title, fifth line of page 15. Okay, we allow this amendment. Let him file a consider amended rate petition. Mr. R.S. Chauhan, learned counsel for the petitioner. Sorry, applicant, as well as Ms. M. Bhattacharya, learned additional senior government advocate. You are additional senior government advocate, appearing for, you're appearing for all the respondents. Next para. By filing this interlocutory application, the applicant, who is the petitioner in the connected WPC 2109 of 2025, is paid for allowing the amendment of the writ petition, including its synopsis and list of dates, in the manner as mentioned in paragraph 8 of this application. Next one. Having heard the learned counsel for the applicant as well as the learned additional senior government advocate, the prayer stands allowed. The applicant shall applicant said out, just full stop. Then in the main writ petition, you say, heard so and so, in view of order passed today in the connected IA Civil 2958 of 2025, the petitioner shall file an amended writ petition, including cost title and the list of dates within a period of 2 weeks. List as and when the, whatever be, list as and when the amended writ petition is filed.
Item 6.
Time being, you have got the instructions. Yes. Yes. Okay. It's okay. Let the council come then. Okay. After some time.
Item 7.
Same. Okay.
Item 8.
Okay. Okay. Both sides are represented. Ms. M. Bhattacharjee, learned additional senior government advocate, had submitted that he has received the records, but needs some time to go through it and address the court. Correct? Accordingly, the matter stands adjourned today. List again on 17/10/2025. Family pension. Okay. Yes, Tabadar and council appears to respond for 5. Okay.
Item 9.
Just see if she is entitled to the pension. Since you are keeping it after the vacations, if he is entitled to family pension, you can authorize you can tell the respondent authorities to release it in the meantime. Yes, Mr. Manan. Please show it to Mr. Manan. Mr. David. Only you'll have to assure Mr. Manan how many steps are there. You have taken steps, but how many steps have to be gone? No, we understand, but that is your problem. You'll have to tell Mr. Manan when they are receiving it. No, you'll have to do only one thing then. In our system, we have to work for 210 days. In your office, you fix a timing, yearly time, that one should spend so much of time for this pension work. If it is 8 hours a day, how many days a year, how many days a year, how many hours they have to spend in the office? You have to tell them. Because how long will the people wait after having retired? No, whatever we just tell us, the authorities will have to tell us when they are paying. Mr. Manan will be only interested in the. Mr. Manan will be interested only on the date when he is receiving it, not in these letters and steps you are taking. No, we see that if you have funds, then the disbursement should start in a manner in which the authorities deem it appropriate. Because if you have funds, if he is entitled to 100 rupees, give him 10. At least start that disbursement. How much was that? That has been released. Okay, Mr. Manan, then we wait for some time. It's okay. Once you say that something has been released, okay. No, it's okay. We heard Mr. Y.S. Manan, learned counsel for the petitioner. Next, Mr. D. Bora, learned standing counsel for the Guwahati Municipal Corporation, has submitted that he has received instructions that the appropriate steps are being taken by the authorities for release of the pensionary benefits. It is submitted that as per instructions received by him, death cum retirement gratuity has been released in respect of the petitioner, and as well as GPF has been released to the petitioner. Next para. The Learned counsel for the petitioner shall obtain instructions to that effect. Next para. In the meanwhile, it is made clear that the pendency of this writ petition shall not be a bar for the respondent authorities to calculate the other retiral dues of the petitioner and to make disbursements as disbursements in such manner as the authorities may deem fit and proper. Next para, list on. Tell a date, we fix it on that day so that you can get instructions. List on 29/10/2025 for updated instructions from the Guwahati Municipal Corporation.
Item 10.
Pardon me? I'm not getting it. Please repeat again. Oh.
Sairo dilo. Mo milay.
Pardon me? Page 45.
Remaining.
You are reading where? Page 45? Page 34. Yes. No, just a moment. Please come to page 45. If the claim is for family pension, then perhaps the husband is not alive. So number one, it is not possible on part of the petitioner to procure 5A. And this 5A is two parts. Decree of divorce from the first wife, that obviously second wife cannot get. And number two, you say elopement certificate from first class magistrate. A magistrate will never give a elopement certificate. No. Where is that? 20? But this is not a marriage certificate. His notary is not authorized to issue such certificates. Page. Make her a party. Because this is certificate we are finding it difficult to accept. But that's okay. But you see, the authorities can't take a decision on the basis of this document. So if she is a party here, it makes your work easier. No, but pension can't be granted on the basis of Gambura certificate. Heard Mr. H.K. Das, we allow you to implead the wife. Heard Mr. H. Das, the counsel for the petitioner. He praised that the that the petitioner be permitted to implead. Oh no, you have to file an IA. Besides that, non-counsel to the petitioner pays that the matter be adjourned so as to enable the petitioner to file an interlocutory application for impleading the first wife of her deceased husband. Mr. Whatever be the Mr. S.S. Royal and CGC is present. Next the period is allowed. The matter stands adjourned today. List as and when the interlocutory application is filed.
Item 11.
Yes. Time being.
Item 12.
Okay. Okay. All sides are represented. Mr. Anu Padhyal and standing counsel for the irrigation department. Grace. So this is okay. We are saying all sides are present. The standing counsel for the irrigation department prays for some more time to obtain instructions and to address the court on the issue of family pension claimed by the petitioner. The learned standing counsel for the irrigation department shall make an endeavor to obtain the necessary instructions by the next date of listing. Next para list on 17/10/2025. Oh no, not 17. We are making it 24th because again there will be item 13. Yes. promotion. Next meeting is scheduled on 26/9. No, they say that the next board meeting for approval of promotion of Srimati Shyama Devi Locker. It's only 26/9. It's day after tomorrow. It's only day after tomorrow. For this, you don't need an affidavit. We'll record it in the order. And we fix it after the vacation so that they bring it on record, whatever the decisions are. No, but if you take any adverse, if you can take any adverse decision against the petitioner, it has to be by way of an affidavit. You will tell. Day after tomorrow. Had Mr. T.J. Mahota, Learned Senior Counsel, assisted by Ms. P. Sharma, Learned Counsel for the petitioner. Next paragraph, Ms. K. Fukan, Learned Standing Counsel for the AEGCL, has submitted that she has received written instructions dated 22/9/2025 that the next meeting of the Board of Directors is scheduled on 26/9/2025, where an agenda is for approval regarding the promotion of the petitioner from DGM within bracket HR to the rank of GM within bracket HR. Next paragraph. In the said regard, the learned senior counsel for the petitioner has submitted that as per the service rules, the board approval is not required to give effect to the resolution of the DPC. First of it is submitted that the delay in giving effect to the recommendation for promotion would also affect his further entitlement to promotion to the next higher post. But we are not saying anything. First, accordingly, the matter stands adjourned today. List the matter again on 24/10/2025. Next, the respondents should take note that if any decision adverse to the petitioner is taken, the same shall be communicated, same shall be brought on record by filing an affidavit. The instructions as produced by the learned standing counsel for the AEGCL is returned.
Item 14.
Okay, where is the standing council for Assam State Agriculture Marketing Board? This one, NJ Gogoi. You will be appearing? No. You are not appearing in the matter. Just give a scroll for NJ Gogoi. SC ASAMB. AAMB, Assam State Agriculture Marketing Board. Wait for some time. SCASAMB. Item 15.
Item 15. Item 15.
Yes, CGC is there. Yes. In this case, the petitioner is claiming back wages retirement benefit on his reinstatement in service. Yes, this court said that if nobody appears, then adverse orders would follow. You have a copy of the earlier writ petition? Please show it to us. No, don't start reading now. Give a copy of the earlier writ petition. No, you may not have filed it, but do you have a copy of that? WBC 4347. You don't file it, you show it to us. Both sides are represented. Ms. B. Sharma, then at CGC, enters appearance for the respondents and prays for some time to obtain instructions. Your name is? Oh, Mr. H. Bora, learned counsel for the petitioner, shall provide a copy of the writ petition to the learned CGC within 2 days, so as to enable her to obtain instructions. Next para, on the next date of listing, comma, the learned counsel for the petitioner shall produce a copy of the writ petition filed in WPC 4347 of 2015. As it is projected that in the order dated 11/1/2024, passed in WPC 4347 of 2015, comma, there was no prayer for reinstatement, comma, back wages or other retirement benefits But the petitioner was given liberty to claim the same. Next para. The list again on 27/10/2025. Give a copy to her, late petition. Sixteen. Yes, you have given the money. But you say you have funds of 60 crore. Then what is the? No, I don't know, you see, but can I tell you an absurd story? When I was there and somebody told me that you do the, you do your work and the payment will come when the amount is due, when we'll have funds. It was something which I did not entertain. No, you see, if you have, you see, it's very simple. If you have funds and you are not disbursing, then why interest should not be added? No, we don't know. Whatever you have to do, you do your work. These are what you call Anganwadi worker. What was their honorarium? So 500,000 or 3,000 rupees honorarium of a Anganwadi worker. No, we understand, but we are asking the salary. We are asking the salary which you are paying to the Anganwadi workers. It will not be more than 2,000-3,000 rupees. Then if you take more time, why interest should not be added? We are not interested with that. No, we'll say if you don't make the payment by the time we are because next considered, we know is a very good term. Is very good term. You see, we are fixing this matter now after the vacations. So if you don't make payment, Then we put a question, query to the government, why interest should not be added. You. No, no. No, we are not giving any directions. We are just putting a query. It is for your department to say what you will be doing. Let your authorities do the work. Otherwise, they will make payment and then say that it is the court ordered and therefore we are paying. No, no, no priority. You have just now said there are many, many people who have not received it. Then why priority to the petitioner? No, no, no. The authorities are setting our money in paid interest to be realized from them for their inaction in disbursing payments. We are giving you one time, make payment or otherwise show cause why interest should not be added to be recovered from the concerned officials who are found guilty of not disbursing despite having funds. Had Mr. M.S. Mandal, Learned Counsel for the petitioner. Next para. Mr. C.K.S. Barwa, Learned Government Advocate, has referred to the affidavit in opposition filed by the respondent number 2. Full stop. Next para. On a perusal of annexure A to the said affidavit in opposition, we take note of the fact that by notification dated 1/4/2022, the government has come out with a scheme for making one-time lump sum payment of rupees ₹4 lakh, ₹3 lakh and ₹2 lakh respectively on relinquishment of service after attaining the age of 60 years, having rendered minimum service of 10 years. More specifically referred to in the said notification. Next para. In paragraph 3 of the said affidavit, it is projected that the Director, Women and Child Development, Assam, has received a sum of has received a budgetary provision of rupees 60 crore for the financial year 2025-26 in respect of terminal benefit. And it has been specifically stated that out of the said fund, terminal benefit as claimed by the petitioner may be considered as per guideline. Next para. We understand from the said affidavit, the court is made to understand from the said affidavit that budgetary allocation of rupees 60 crore has already been made for the year 2025-26. Just of under such circumstances, the respondent number 2 the respondent number 2 is put to notice that why, despite budgetary allocation, the terminal benefit of the petitioner has not been released. To stop. If the if adequate funds are made available to the respondent number 2, or the non-disbursement of the terminal benefit has to be explained to the court. Accordingly, the court is inclined to provide that by the next date of listing, if the terminal benefit of the petitioner is not released, the respondent number 2 is put to notice to show cause as to why a delay has occurred for non-disbursement of the terminal benefit of the petitioner, and also to show cause as to why an appropriate order should not be passed by the court directing interest at the rate of 9% should not be imposed on the state for non-payment of retired dues of the petitioner despite budgetary allocation being available to the Directorate of Women and Child Development Department. Next paragraph. The learned government advocate shall send a downloaded copy of this order to the respondent number 2 to bring the order to the notice of the said authority. Next, the affidavit shall file at least 2 days prior to the next date of listing. Next paragraph list on 29/10/2025. So before that, you say that pendency of this rate petition shall not be a bar for the respondent authorities to release the payment due to the petitioner. So you are also there, Mr. S. As per and it's standing as for respondent numbers 3, 4, and 5. And Mr. Barwa, you will be for 1 and 2. Okay.
Item 17 with 18.
Who's there? Yes. $14. So that. Just a moment. We don't have the file. Yes, what have you said about MACP? Just a moment. What have you said about MACP? No, why will somebody apply if the MACP is required to be given? Do you grant MACP on application? Then? No, that's okay. He took a VRS. But his entitlement on the day of VRS, can you deny it just because he has not applied? We'll put the question in another way. You see, you appear as standing counsel. Let us assume that per day appearance of yours is 20,000. We are just presuming. Per day appearance is 20,000. Now today a notification has come which makes the daily entitlement of yours as 25,000. And after 10 days you resign. Do you think that the authorities shall deny you that 5,000 extra just because you have, after 10 days you are resigning? Now we are asking you a question. Take it on you. You are entitled to a disbursement of 20,000 per day per appearance. Today it is being enhanced to 25,000 per day per appearance. Supposing you resign on 30, can you be denied this 5 days additional remuneration of 5,000 per day? If you say yes, we agree to it. We record your statement. In MSCP, whether an application is required for number 1, shows the scheme where application, it is dependent on an application to be made, is not there. So who is the brilliant person who has given you the instructions that he did not apply, so he will not get? We'll ask for personal appearance of the officer. We'll ask him that unless he applies, he will not get his pay every month, every year. There's a pay enhancement. He will forego that. He file an affidavit that unless I apply, I will forego all my additional dues which I am to get. Correct. Tell him to make some sense. Next time when he files an affidavit before the court, let him examine with some sense of responsibility. We'll be into deep trouble. Paragraph 5. It's okay, he has understood it. Let him take instructions. Okay. Your name? Your name? Mr. P. Sharma, and constitute the petitioner, was submitted that in the affidavit in opposition filed by respondent number 3, I don't know if this is respondent number 4, then I'll have to rise and go to doctor. Now, please tell me, please advise, do I have to go to a doctor? I don't know typographical error. If that is your expectation, it is very high expectation of you for a court to find out the typographical error and then tell you. That is your expectation? Charles Dickens wrote a book, Great Expectations. Have you read that? Filed by respondent number 3. If it is not 3, then we will sing some other music on the next date. Number 3, the Chief Executive Officer of the Assam State Agriculture Marketing Board has admitted in paragraph 5 thereof about the entitlement of the petitioner to MACP S with effect from 1/1/2017. Full stop. However, in a U-turn, in the additional affidavit in opposition filed by respondent number 4, the Chief Executive Officer of the Assam State Agriculture Marketing Board in paragraph 4 has stated that no request for any revision is maintainable as per the policy decision of VRS by the department as per the notification dated 15/2/2006. Next paragraph. Accordingly, the Chief Executive Officer, Assam State Agricultural Marketing Board is put to notice to inform the court that under which policy, the benefit of MSCPS, already accrued in favor of the petitioner with effect from 1/1/2017 can be withheld in your writ petition. Where is the date of your applying for VRS? Page, give us the page. Page 37. Inasmuch as the application for availing voluntary retirement scheme was made by the petitioner on 12/8/2024. Next paragraph. The filing of the affidavit the affidavit in terms of this order shall not be a bar for the Chief Executive Officer, Assam State Agricultural Marketing Board to release the MSCPS benefit to the petitioner, if he is found entitled to prior to the date of applying for VRS. Next para, list on 29/10/2025. Next para, before that you say that the learned standing counsel for the Assam State Agriculture Marketing Board shall send a downloaded copy of this order to the Chief Executive Officer, ASAMB. Mr. Barpujar, you are appearing for respondent number? Respondent number 2, Mr. R. Barpujar, Standing Counsel of Finance for respondent number 2. And Mr. Gogoi would be for 1, 3, and 4. Only 3 and 4. Then Department of Agriculture, respondent number 1. You're there? Miss R. Bora. Okay. Your name? Miss C. Saikia, on behalf of Miss R. Bora, Standing Counsel for the Agriculture Department. Respondent number 1. Okay. '17-18 When did your predecessor died? Date of death? Five 2007. You applied on 23/5/2013. But after this decision of what do you call that? Huh? No, that Achyut Ranjan Das. After 2 years, it is deemed to have spent force. Yeah. 30. Okay. But compassionate appointment, can it be done without SLC approval? Thirty-six. No, under the scheme of compassionate appointment shows that it is not required. SLC is not required. Shows that. Not referred. Not referred. Mhm. You are appearing for BTC. Karbi Anglong. So if this is a consent by the BTC, how can it bind Karbi Anglong Autonomous Council? Ah, no, 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 no. No, no. You see, six schedule areas, which is the controlling department? Hills, what do you call it? It is called Hills Areas Department. Just let him complete his part. You see, whatever you say, but unless you, I hope you are aware of the scheme of appointment in the state government. Once it is authorized by the controlling department, then the appointments are made, and the first salary comes from the finance department, that is SIU. Unless the first salary comes from the SIU finance, where you are showing it. $38. But his salary was stopped due to want of approval for SIU department. Correct. That's what we are saying. That is the scheme of the government. First payment has to come from it, has to originate from finance SIU department. First salary, it is not the BTC or KAC who will be paying it. It comes from the government of Assam. If the money is charged to the government of Assam, if it is an appointment solely within the jurisdiction of KAC, it will come by their CEO. So parity won't apply. In these cases, parity won't apply. Show it to Mr. Uh, no, not even that. You look at this order. You have seen the order. You- Shows the earlier OM. Okay. That's all. You have anything more to say, Mr. Barbuya? You have anything more to say? No, it's okay. We have it. We are getting it out. My court master is searching for it. Okay. You have anything more to say? But please tell me, if you are relying on the High Court order passed way back into in the WPC 2451 of 2011, why you have made prayer number 3 for the SLC to approve? SLC doesn't approve salary if I am no. Mr. Varmaya, we expect something more from you. No. This appointment was illegal. Could not have been done. Yes, Mr. Sudhya. Yes. My court master has retrieved this OM. Last OM was 2nd March 2009. Okay, yes. Transfer subjects. This corporation department is not transfer subject. No, we are disposing it of. We don't have, we won't overburden ourselves. We'll take account of that. We'll take account of that. Okay. Heard. Mr. J. Borvial and counsel for the petitioner also heard. For the government who's there, you're, yes. 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 28. Yes. We have seen that. This Achyutaranjan Das, what is this addition? I forgot. Hmm. Okay. The government will be appearing, you'll be appearing, this Ambassador and additional senior government advocate appearing for respondent number 1 and 2, Mr. R. Barpujari, and standing question for the finance department, comma, respondent number 3. SLC would be she will be for 1, 4, 1, 4 and 9 also then. Treasury, you will be for treasury. Acha, 3 and 9 would be Mr. Barpujari. Okay. Mr. J. Sutyal, and standing question for the KAC, representing respondent numbers 5, 6, 7 and 8. And Ms. MD Bharat, and standing counsel for the Cooperation Department, representing respondent number 2. Huh? Okay. We're taking up one after another. We're not mixing up two things together. Next, filing this writ petition under Article 226 of the Constitution of India, comma, the petitioner has, comma, inter alia, comma, prayed for issuance of writ in the nature of certiorari to set aside the minutes dated 2/3/2023, comma, passed by the state level committee within bracket SLC, semicolon, for setting aside the OM number ABP full stop 102/2024/90 dated 18/9/2024, issued by the government of Assam, comma, personnel B department. Where is that? Where is that OM? Which page? 50. Okay. Semicolon. For issuance of direction to the respondent authorities, including the SLC, to approve the appointment and recommendation of the DLC, comma, Karbi Anglong for appointment of petitioner on compassionate ground, semicolon, and for directing the respondent authorities to release the salary of the petitioner, including arrears salary. Next para. In brief, comma, the case of the petitioner is that his father, while serving as the senior inspector oblique auditor in the office of the additional registrar of cooperative societies, comma, Karbi Anglong, comma, Difu, comma, died in harness on 5/12/2007. The petitioner projects that the application for appointment on compassionate ground was submitted on 2009. No, am I wrong? Am I wrong? We don't know about that. I gave a date. Am I wrong? On 2012/2007, comma, followed by another application on 28/4/2010, You know, you should not have shown me this document. This is one document you should not have shown it to me. You had allowed you should have permitted to make make a mistake. Come to page 22. We'll show you why. In page 22, annexure 2, which you say is made in the year 2007, your age, your date of birth is given as 13/11/1982. Correct? Correct. We are showing you page 22 of where you are checking it up. We don't have time. It's 4:30. We'll have to rise. There are a lot many learned counsel sitting here. 82. 1982. Serial number 3. Khorsing Timung. Your age is 27 years. Correct. So it has to be 2009. You could not have made this application in 2007. You are creating a false document before the court. We don't know. We are showing you the document. No, whatever be, he's shown me a document and he's trapped there. When I read a document, I read it. Next para. It is projected that by the minutes of district level committee meeting, within bracket DLC for short, held on 29/1/2014, the name of the petitioner was recommended for appointment on compassionate ground. Full stop. It is also projected that by a letter dated 3/1/2020, issued by the Secretary, Department of Cooperation, Karbi Anglong Autonomous Council, the approval was granted for appointment of the petitioner in the vacant sanction post of LDA on compassionate ground. Full stop. Accordingly, by order dated 25 January 2021, issued by the District Deputy Registrar of Cooperative Societies, Karbi Anglong, the petitioner was appointed to the post of LDA on compassionate ground in the office of the Assistant Registrar of Cooperative Societies, DIFU, Karbi Anglong. And the petitioner projects that he gave a joining report on 29/1/2021. Full stop. It is further projected that by a letter dated 8/3/2022. No, you got payment for which time? So it is projected that in the meanwhile, the petitioner received his salary up to so and so. Yeah, gap will be. February to July 2021. Full stop. Thereafter, on a query raised by the Hills Area Department, Government of Assam, the Deputy Secretary to the Department of Personnel -B, Karbi Anglong Autonomous Council had informed the said authority that Autonomous Council in the 6 scheduled areas is empowered to appoint grade 3 and grade 4 post, the matter relating to appointment of the petitioner was not referred to the state level committee within bracket SLC for short. So thereupon, a proposal for approval was proposal for approval of the appointment of the petitioner was sent to the Corporation Department, Government of Assam by letter dated 20/12/2022 by the Department of Personnel -B, Karbi Anglong Autonomous Council. However, the SLC in its meeting minutes held on minutes of meeting held on 2/3/2023, rejected the proposal for appointment of petitioner on the compassionate ground, inter alia, on the ground that on the date of that the date of application was 23/5/2013, which is 5 years after the after the death of the petitioner's father. And accordingly to the SLC did not recommend the name of the petitioner in light of the OM dated 1/6/2015. Post of the Department of Personnel -B, Karbi Anglong Autonomous Council, resubmitted a proposal to the Corporation Department for approval of the state level committee. And as nothing has been done so far, the present writ petition has been filed under Article 226 of the Constitution of India. Next, in support of his submissions towards entitlement of the petitioner to appointment on compassionate ground, the Learned Counsel for the petitioner has produced a copy of order dated 22/3/2012, passed by this court in WPC 2451 of 2011. The project that in respect of the BTC, Borderland Territorial Council, it has been held that 6 scheduled areas are not required to route their appointment on compassionate ground to the SLC, and the DLC of the BTC was held to have jurisdiction to have its own DLC for considering appointment on compassionate ground. Full stop. The Land Council for the Petitioner also places reliance on the order dated 22/9/2023, passed by this court in WPC 5534 of 2023, the project that the petitioner therein was directed to be paid her salary if the said petitioner is found to have worked in the office of the Assistant Public Deputy Registrar of Cooperative Societies, Karbi Anglong, Difu, as the said petitioner was appointed on compassionate basis. Next paragraph. Opposing the prayer made in the writ petition, the learned standing counsel for the Karbi Anglong Autonomous Council has submitted that the appointments under the Cooperation Department in the office of the Additional Registrar of Cooperative Societies and authorities thereunder, or the same being a transfer subject, is to be done in accordance with the rules and regulations in force of the state government, and only in respect of the transferred subjects which are retained by the Karbi Anglong Autonomous Council, the authorities would have the power to appoint personnel. First of it is also submitted that in respect of the non-transferred subjects, the first salary is to be released by obtaining finance within bracket SIU bracket close approval from the Finance Department of the Government of Assam. Full stop. The said submissions are also reiterated by the learned standing counsel for the Finance Department as well as the learned standing counsel for the Cooperation Department. By further submitting that the ratio laid down in the case of Achyut Ranjan Das within take that 2006 4 GLT 674, read with the decision of this court in the case of Faziron Nasa 2010 within bracket 4 bracket was GLT page 348, as the application was found to be beyond the prescribed period of limitation, the said proposal was rightly rejected by the SLC. Next paragraph. On facts, have I left out anything? No. on facts or submissions, have I left out anything? Let me have written. I said, no, not transferred. This is not a transferred subject. It's a transferred subject. Oh, okay, so make it transferred subject. Cooperation department is a transfer subject where the Karbi Anglong Autonomous Council authorities will have to follow the state rules, which includes approval by the DLC as well as SLC. Correct. I was thinking it's a non-transfer subject. It's a transfer subject. Okay. Anything I've left out? No. Yeah, I have to rise. There's a meeting right now. So. Okay, I'll dispose it off. It will take some time, but. Yes. 24. What is the matter about? What is the matter about? No, if he's wanting time, it's same thing will happen tomorrow. Okay, you are appealing for? Achha, contempt petition. Okay, contempt petition. But Mr. S. Das, Learned Counsel for the petitioner. Mr. Miss M. Bhattacharjee, Learned Counsel, letters appearance for respondent 1 and 2. You're also there? Was this someone? And place for some time to obtain instructions and to file affidavit in opposition in the matter. Stop. Accordingly, matter stands adjourned today. List on 24/10/2025. So the affidavit shall be filed at least 2 days prior to the next date of listing. No, day after tomorrow is very difficult. We'll fix it. What is the urgency? Which department? Soil, anybody is there? Soil conservation, you have instructions? Yes, but he can't do it. Unless there's a government approval, he can't do it. You can't help it. By judicial orders, you can't get appointment. We'll. Yes, the instructions. Once he says he has instructions, we have some faith on him. Okay. This is item number. Your item number is Ms. N.S. Thakure, and counsel for the petitioner, who submits that there is some urgency in the matter. Mr. A. Shalia, and counsel appearing for respondent number 5. Prays for some time to prays for some time as the department, as the concerned department has moved the government for doing the needful for compliance of the order. Next, accordingly, matters stands adjourned today. List on 17/10/2025. Okay, make it 17/10. No, make it 15/10. Item number 6 and 7. Yes, Mr. Das. In 7, you are there. So you have a respondent number? Mr. H. Das for all the respondents. H. R. Das. H. R. Das for respondent was 7. All the respondents. Who's for the respondent? Which department? Agriculture. Who is there for agriculture? Okay, make it tomorrow. Okay. Okay. $20? 11. Okay, 11 is 1510. We don't know, we are fixing it tomorrow. Okay. 20. 28. Don't tell us about third time, fourth time. We are working overtime right now. Correct? 28. It's a hearing matter. Or 25. After vacation. Date to be fixed by the registry. Had we not been working overtime, we would have appreciated. But this is something which you have to live with it.